Judicial Activism, vis-a-vis environment protection and people response through PILs. Judicial activism means proactive role of judiciary in addressing environmental issues, particularly when legislative and executive actions fall short. Involves interpreting and expanding the scope of constitutional provisions to ensure environmental justice and safeguard the fundamental right to a healthy environment as enshrined under Article 21 of the Constitution. Through judicial activism, courts intervene to protect natural resources, prevent ecological degradation, and hold violators accountable. This includes passing judgments based on public interest litigations, issuing guidelines for pollution control, and mandating compliance with environmental laws. It is with a view to protect and preserve environment and save it for future generations to ensure good quality of life. Legislature has enacted anti-pollution laws and incorporated many statutory provisions for protection of environment. In case Indian Council for Enviro Legal Action versus Union of India 1996 5 SCC 281 at 293, popularly known as the Coastal Protection Case, it was held violation of anti-pollution laws not only adversely affects the existing quality of life, but the non-enforcement of legal provisions often result in ecological imbalance and degradation of environment, the adverse effects of which has to be borne by the future generations. In another case, Law Society of India versus Fertilizers and Chemical Travancore Limited, AIR 1994 Kerala 308 at 321, it was held that the environmental imperative is ultimately a matter of public and private rights and duties and interests of the future generations, which are not available as negotiable commodities to be purchased at any going rate. Effective environmental protection and improvement is a matter of legal rights and duties. Therefore, it is essential for people and they should be aware of adverse consequences. They should not only protect and improve environment but also ensure compliance of anti-pollution laws, and if needed, take help of judicial forum to enforce such laws to maintain ecological balance. People's response to ecological crisis has been very positive in India. In certain cases, they have formed pressure groups and exerted influence on government to take decision on certain developmental projects only after making proper environment impact assessment (EIA). Example number 1, Silent Valley Movement in Kerala. Example number 2, the role of non-governmental organizations in this regard is very important. Example, Wildlife Protection Society of India and Ashoka Trust Research in Ecology and Environment. Example number 3, the scientific and academic community has contributed their share in environmental decisions by new researches. 3 examples of which are National Environmental Engineering Research Institute, Nagpur, the Center for Science and Environment, New Delhi, the Center for Environment Education, Ahmedabad. Example number 4, some people showed their concern through public interest litigations and got favorable directions from court in appropriate cases. Example, MC Mehta single-handedly filed a number of public interest litigations in Supreme Court relating to different aspects of environment pollution. 5. Environmental activists, lawyers and judges have made their significant contributions, like Sri Sundarlal Bahuguna. Jadav Payeng, called Forest Man of India, created forest over 1,360 acres of land. Example 6. Local people of municipality have raised their voices against local authorities for the non-performance of their duties. Example, in a case Municipal Council Ratlam versus Sri Vardi Chand, Supreme Court ruled that municipality must provide basic sanitation facilities to its residents even if it faces financial difficulties. Case established that municipality could not avoid its duties by claiming lack of funds. In India, people have responded to environmental issues at local level, zonal level, state level and at national level in different ways. India's different laws relating to environment protection recognize the role of people in protecting the environment. Example, Section 49 of Water Prevention and Control of Pollution Act 1974, Section 43 of Air Prevention and Control of Pollution Act 1981, Section 55 of Wildlife Protection Act 1972, Section 19 of Environment Protection Act 1986. Further examples, Chipko Movement, Apiko Movement in Karnataka for saving forests from exploitation, Silent Valley Project led by Kerala Shastra Sahitya Parishad, Narmada Bachao Andolan led by Baba Amte and Medha Patkar, Tehri Bandh Virodhi Sangharsh Samiti led by Sri Sundarlal Bahuguna, has been protesting against the construction of Tehri Dam due to its adverse environmental effects. Judicial response to almost all environmental litigations has been very positive in India. Primary effort of the court while dealing with environment-related issues is to see that the enforcement agencies, whether it is of the laws, even if it is not function of courts but because of non-functioning of enforcement agencies to implement law, courts as of necessity have to pass orders directing them to implement law for protection of fundamental rights of the people to live in a healthy environment. In Coastal Protection Case, it was held that passing of appropriate orders requiring implementation of law cannot be regarded as court having usurped the function of legislature or the executive. Limitations. Example, in some cases, frivolous or vexatious writ petitions are filed in name of public interest litigation involving environmental matters. It has been noticed that such litigations are filed mala fide and arise out of enmity between the parties. sometimes the judicial order is not fully obeyed by the parties concerned. Even the government and its agencies like Pollution Control Board have been issuing directions contrary to the orders of the court. In case MC Mehta vs Union of India, AIR 1987 SC 965, popularly known as oleum gas leakage case, it was held that courts also do not have any scientific and technical expertise in environmental cases, and thus it has to depend upon the findings of various commissions and other bodies. Therefore, courts have suggested for setting up of environmental courts to deal with environmental matters. In case Vellore Citizens Welfare Forum vs Union of India, popularly known as the Tea and Tanneries case, it was held that the government has set up the National Environment Tribunal to deal with the environmental matters. Conclusion: judicial activism has been hope for environmental justice, bridging the gap between policy and implementation, and reinforcing the principle that a healthy environment is fundamental to the well-being of current and future generations.